Good afternoon. It's February 25, 2026, and this is Charles Carrion, and I am here in Silver City, New Mexico to talk about law and policy and visionary medicine and search warrants and the Department of Justice. And let me start out by sharing my screen with you here. I want to show you something that, let's see, screen. Here we go. Done at last. Alrighty. Federal judge rejects government's request to search Washington Post reporters' devices. And this pretty much tells a story that federal judge rejected the Department of Justice's demand to continue its search of a Washington Post reporter's phone and other electronic devices for information that might help an FBI investigation into the leaking of classified information. So this is another case of the DOJ managing to get in trouble with the federal judge, basically because, as we're going to discover, they just don't care about following the law and very likely really just don't know what they're doing. They're embroiled in ethical misconduct everywhere, and the reason is pretty simple. They have fired or seen most of the smart lawyers at the DOJ leave because anyone smart is not going to work in a slave factory where you're forced to lie to judges and you don't even get to have the dignity of being an honest advocate. It takes a stupid, not very, intelligent person to think that that's the right way to conduct a law practice. And so that's really all they've got left at the DOJ. I mean, I'm sure there are some people with brains and no ethics, but that's kind of a rare combination, actually. Ethics leads to intelligent conduct, and intelligent conduct always suggests ethical approaches. So where are we going to start out? Well, I'm going to tell you what happened here. I've got some notes that I'm going to refer to. What happened was January 8th, 2026, the Department of Justice charged a man named Perez Lugones, that's just his last name, Perez Lugones, arrested him and charged him with unlawful retention of defense information. And then 4 days later, on January 12th, they went to the court and they said they needed to search Natanson's house and seize all of her devices. And because there was information about her communications with Mr. Perez Lugones. Why would she have communications with him? Because she has assiduously cultivated informant relationships on the r/Fed News subreddit on Reddit and has actually contacted 1,200 leakers who are communicating with her or have been communicating with her via Signal. And so apparently this is one person who is, the government claims, has leaked information to Ms. Natanson, who is a Washington Post reporter. The judge denied the search warrant because, as usual, the Department of Justice doesn't really have control of its case anymore. They just have to rush ahead and do whatever the crazy man at the top of the heap is shouting about today in his orange rage. And so the warrant is rejected. And the next day they try again. They bring in heavier people and it's rejected again. Then the magistrate judge, altogether too kindly, spends 5 hours going back and forth with these guys and finally issues a search warrant with very specific limits to only information about Mr. Perez Lugones' communication from October 1, 2025 to the present. So basically what's up? It's about a 5-month period about one man. What do? Well, they execute that search warrant and they seize basically all of her laptops, her phones, everything, put her completely out of business. All of her sources go silent. And therefore, Pam Bondi accomplished her goal. She destroyed Ms. Natanson's ability to communicate with 1,200 informants They're not coming forth anymore. So mission accomplished. And when you think that there's a victory here, well, there is, but only to the extent that we can start getting the Department of Justice to behave justly, because that is not what it is about. And you know that. I know that. The Department of Justice lawyers are then contacted by the Washington Post lawyers. They talk for 6 days. DOJ guys are never able to do a deal because they don't have any authority, so they can't agree on anything. They refuse to hold off on searching the materials any further. Washington Post lawyers go to the court and invoke an important search warrant case from the Fourth Circuit and get a standstill order, and apparently the government complies with it. A standstill order meaning don't look at anything. So then the arguments are joined. And what happens? Well, let's go ahead and take a share of the article itself, of the court ruling. Where is it's not showing up. Maybe if I open it in a tab, that will probably, doesn't want to see it in Adobe, so sorry guys. Okay, there we go. Now we should be able to see it for you. Okay, so share away. And screenshot. There we go. Okay, folks. So taking a look here at the screen share, we've got the basic facts that we just went through. And now we'll go down to the point where the judge starts blowing up, because it's worth giving it to him verbatim. These are all the facts that I just went through. And here we go. And so then the judge goes through the arguments of both parties. The government, of course, says it can keep everything and that their lawyers can sort through anything that needs to be sorted through. And of course, the Washington Post lawyers say, no, you should just give it back to us and we'll comply with the subpoena that you sent to the Washington Post. And so those are basically the arguments that are posed. And then, of course, there's the alternative of having the judge go through the files and not letting the Department of Justice do it because they can't be trusted. And ultimately, no suspense here. That's how the judge rules. But let's take a look at this part. Before reaching the merits, the court addresses a matter of significant concern: the government's failure to identify and analyze the Privacy Protection Act of 1980 in its search warrant application. Okay. And so he says, the court had never received such an application. In other words, never received a search warrant application to search a reporter and was unaware of the PPA. Okay, I just want to do a quick little experiment and see how it goes if we just go directly over to ChatGPT, and I'm going to share a different page with you now. Just go over to ChatGPT and see what happens. I haven't tried this. See what happens if we ask it. As a federal law expert, please identify any statutes that regulate the DOJ's use of warrants to seize information and property from reporters. Journalists. Let's see what happens. Let's see if the judge could have figured this out using ChatGPT. There we go. It's working away. Yep, there it is. Pops up right away. Important statutes like the Privacy Protection Act. Okay. So here the magistrate judge probably got himself, he's probably got 3 really smart clerks, them do the basic stuff. So there you go. Just assuming that a judge is going to research the law just because it's a search warrant application. That's a big assumption to make, and apparently not a safe one. So let's go back to the opinion because it's filled with juicy stuff. And go back to the opinion. Yeah, you can learn something by reading them. And what do I want to learn here? Well, I want to learn what they did that was so bad. Okay, and what they did is right here. The PPA, the Privacy Protection Act, is directed at government lawyers, and its terms require the Attorney General to issue regulations. Oh, wow. They already issued them. Look, they're here at 28 Code of Federal Regulations, 50.10A3. Gee, you'd think they might know that. And the Department of Justice Manual 913 for, oh gosh, just how can you help but want to look that up, you know? Give me a second here. Let's find their Justice Manual. Take a look at that. Oh, look at this. Obtaining evidence. There it is. It's right, it's right in here. So let's switch you over here and let's take a look at it. Here we go. See, they have a whole manual over at the Department of Justice. The thing is, they don't like to read it. And so what did we learn? We're supposed to be looking at 9-13-400. So that's not very hard to do. Here it is. Gee, whole code, federal regulations, and Justice Department manual section. Obtaining information from or records of members of the news media and questioning, arresting, or charging members of the news media. The purpose of these regulations is to strike the proper balance between the public's interest in the free dissemination of ideas and information and the public's interest in effective law enforcement and the fair administration of justice. Under this policy, the department will continue to limit the use of compulsory legal process, recognizing that investigative techniques relating to news gathering are an extraordinary measure to be deployed as a last resort, one's essential to a successful investigation or prosecution. So let's ask ourselves how they did in reaching the balance. What did they do? They were looking for information about one leaker who had been criminally charged. So they seized all of her computers, all of her phones, all of her written work, and put her completely out of business. So it would seem to me that they got that policy completely upside down. They have caused huge harm to obtain a tiny bit of evidentiary benefit in one case. What we see here is, as I said, a lawless Department of Justice that is bent upon what they have already accomplished here, which is to silence leakers and to intimidate the press so that they don't pursue these kinds of stories. And it didn't work. The judge was quite disturbed by it. He was quite upset by the shenanigans they pulled. And I'm going to take a look at another source of info here for me. Get you some quotes from the judge. They tell him, "Oh, we didn't know either." And the judge says, "How could you miss it? How could you think it didn't apply? And what effect did it have on the case?" Judge said, "This omission, this failure to tell me about the Privacy Protection Act has seriously undermined the court's confidence in the government's disclosures." And the third one, the court finds that seizing the totality of a reporter's electronic work product constitutes a restraint on the exercise of First Amendment rights. And nothing like a good cliche to wrap up the analysis, the equivalent, letting the government look through the documents without any control over that is the equivalent of leaving the government's fox in charge of the Washington Post's henhouse. So the judge was not pleased. It caused them to lose this. This was called a 41G motion under the rules of federal criminal procedure, and it allowed them to dig into the honesty or dishonesty of the FBI agent who swore out the affidavit. Now I'm going to segue over into a topic of my own interest, which is visionary religion. And I'm going to discuss how the visionary religion community suffers from the same types of abuses that Natanson suffered in this case. Now, what happens in your average case that involves a visionary religion practitioner? They usually end up having their home searched because they ordered some vegetable substance from Peru or Colombia, usually Peru. And it might be ayahuasca. It might contain a little bit of DMT. It might be coca leaves. Let's just say it's one of those. And so both of those are scheduled controlled substances. Ayahuasca contains a controlled substance, which is dimethyltryptamine, and therefore the government considers it a controlled substance, even though ayahuasca itself isn't on the list, but DMT is. So what happens is the government gets a search warrant. The postal letter carrier comes, delivers the item, and that is surveilled, and then the police swoop in and they say they have accepted the contraband. They come in, they search the entire home. And this happened recently to a client of mine in California, and the amount of contraband seized was ridiculously small. It was just absolutely absurd. And it immediately brought law enforcement in the homes of these people. They were threatened with, of course, weapons and cross-examined about everything they do in their own home and forced to give up information about their friends and forced to go through the contents of their cellular phone, open it up, and allow these DHS. Straightly speaking, you don't need to open your phone. Just remember that. You're not required to unlock your phone. Call me. But it put me in a situation where, on behalf of another client who was implicated by the statements of these folks whose house was searched, we had to reach out to DHS on their behalf and tell them to not pull the same trick with my client, the client who had not been searched. And because why? Because like there is a Privacy Protection Act that is intended to protect reporters, there is a Religious Freedom Restoration Act that is intended to protect the practitioners of visionary religion. It's the Religious Freedom Restoration Act, and it provides that you shall have a defense to federal criminal charges of importing or trafficking or manufacturing or distributing under the Controlled Substances Act if you're a sincere religious practitioner and this is a practice that you engage in as part of your religious free exercise, your right of free exercise. And so I wrote a letter to the Department of Homeland Security agents, and I copied 13 San Francisco Department of Justice attorneys via email, and I had it delivered to each of them personally at their Golden Gate office there in downtown San Francisco, advising them of the existence of RFRA. Good idea, since, the ones who are searching reporters' houses don't know there's a PPA. Well, you might as well tell the ones who are chasing after visionary religion practitioners that there is a law applicable to that. And then I provided some information showing that indeed this contraband substance is used for ceremonial purposes, and therefore you have to tell all this to the judge. If you don't tell it to the judge, then after you get your warrant, what'll we do? We'll move filing what's called a Franks motion under the federal rules of criminal procedure. And the Franks motion will allow us to inform the magistrate or the judge who issued the search warrant that the government's agents lied to them, that they were in bad faith, that they either concealed relevant facts or relevant law, as the attorneys did. In this case, the FBI agent probably didn't have to do much lying. It was the deception by the attorneys in not telling the judge about the Privacy Protection Act. And that deception occurs routinely in all of these drug interception cases. And attorneys for visionary religion practitioners need to know how to attack unlawful search warrants, just like the Washington Post lawyers did here in Natanson's case, and got a good result. So thank you for listening, and please come back, follow whatever you're supposed to do to make this podcast be a regular thing that you do. Please do that, and we really appreciate your visit, and we'll see you again soon.